Arkansas was a very, very primitive and backward place in 1819.
One of the original Superior Court justices, Andrew Scott, was a somewhat hot-headed gentleman. He killed a fellow judge in a duel.
They really didn't have a home at the time.
When you go back and read some of the opinions of that era, you have to be somewhat impressed of the scholarship.
The Supreme Court is the highest court in the state system. It is primarily an appellate court. That is, decisions from lower courts are appealed to it. It also serves as a supervisory body for the lower courts.
The role of the Supreme Court is to be a final adjudicator of litigation, whether it be in the state or federal. We have two types of courts, the state courts and the federal courts. But it is the final arbiter and renders the final decision.
They take their own sweet time writing up those opinions, and then they publish them as a set of decisions. In Arkansas, that's the series known as Arkansas Reports.
When a case comes forward on appeal, it goes through a process. The lawyers furnish briefs to the court to state their positions, and then the court also gets the transcript of the testimony of all the pertinent parts of the court. And your first hearing is, for example, if it was my case, I present the facts, I go over the issues that the various lawyers have discussed, and if I feel like the lower court was right in everything he did or she did, then I would affirm the case. If I found there was error in the case rising to the level of being, shall we say, improper, then it's reversed. It can be reversed and dismissed, that no case at all really should be up here in the first place, or it's remanded back for trial. Well, I present the case, it goes around the room, and each judge votes.
Since the Supreme Court is not a criminal court, it's not usually a court of primary jurisdiction, you have no dock in which the prisoner stands to be sent down for a crime or something like that. Instead, the court sends orders or writs to the lower courts.
Well, you have all sorts of writs. Writs is really kind of a legal writing to the court. You're asking for some sort of relief.
One is the writ of error, in which the court says, in effect, got it wrong, guys. You have the writ of supersedeas, that is, ordering the lower court to stop an action. The upper court is superseding them. You have the writ of certiorari, in which the upper court, the Supreme Court, tells the lower court, make sure of your facts.
You've got a writ of mandamus, so to mandate, you're asking the court to mandate something. Writ of habeas corpus usually is when someone is confined and the jail does not want to let him out or her out, and you file a writ with the court to remove that person from the jail, let it go bond or whatever.
And then you have the writ of quo warranto. That is, by what warrant or on what authority do you act? This is when the high court asks the lower court, did you really have jurisdiction or did you really have authority over this matter? By these writs, the Supreme Court can make sure that the lower courts have done their work well, forcing them to reconsider what they've passed on to the upper court for consideration.
Arkansas was a very, very primitive and backward place in 1819 when it was named a territory of the United States. And so the early justice reflected that primitive state. Well, I think maybe 2 days after Congress made Arkansas a territory, President Monroe appointed 3 men to be justices of the Superior Court, which was an early version of the Supreme Court.
Charles Jewett, Robert Letcher, and Andrew Scott. And there's some question as to whether or not all 3 of them actually showed up on time to begin the deliberations of the court. And of course, they showed up in advance of the governor who had been appointed, James Miller, who doesn't in fact arrive in the territorial capital of Arkansas Post until I believe after Christmas. They were put to work because the territorial secretary, Robert Crittenden, convened them as the first legislature of Arkansas Territory.
So Andrew Scott was the first judge who arrived, and his first case was a rapist, and he convicted him and sentenced him to be castrated. But before the sentence could be carried out, the territorial governor pardoned the guy, so he was not castrated.
You might say, what is the Superior Court doing dealing with a criminal matter? Well, if there is no other court, they in fact were the court of first jurisdiction because they were the court that was there.
The first judge to arrive to associate himself with Judge Scott on the Supreme Court, they got into some kind of dispute, and so they challenged him to a duel, and they went across the river. At that time, the capital was at Arkansas Post, which is down on the banks of the Arkansas River in southeast Arkansas. So since dueling was apparently illegal in Arkansas under the laws at that time, they crossed the river into Mississippi on a barge and had their duel across the river, and Judge Scott killed his companion justice. But he was acquitted of that, and so he was never punished for that. So that was the nature of the justice at that time. And it's pretty obviously crude and primitive, but it was a crude and primitive society that they were to be sitting judgment upon. When Arkansas became a state in 1836, it had to operate under the new Constitution.
Well, the Constitution actually set down certain specifics about how many judges you would have, the qualifications of the judges, the age factor, and their jurisdiction.
The Constitution of the state of Arkansas, adopted in 1836, makes the Supreme Court elective. But it's not elected by the people, it's elected by the legislature.
That's been a problem throughout Arkansas history and the history of many states, that there were elected judges and frequently inferior to the legislature and the governor.
They get 8-year terms, so if you can survive the perils of living in Little Rock, not a bad job at all. It reduces judiciary independence to some extent because you are an elected official, and you are to some extent at the whim of the legislature.
But it gave the Supreme Court unusual power to do almost anything it wanted to do until the Constitution of 1874, which is the one we're still living under, removed some of those unusual powers awarded by the Constitution of 1836. The justices largely reflected the social mores and the customs and the political leanings of the people, and they supported the institutions like slavery and so forth. And the justices also tended to be very close to the ruling elites at the time.
Arkansas's early political history is dominated by a family cabal, if you will. Men interrelated by marriage or blood, the Seviers, the Conways, the Rectors. Interestingly enough, the first Supreme Court, you don't have much of a family connection there. However, during the 1840s and 1850s, members of the family find their way onto the court, including Henry Rector, the future governor of Arkansas. There were a couple of Conway in-laws as well in the 1840s, one of whom served as Chief Justice. It was hard to get away from the family, no matter where you were in Arkansas government.
I mentioned that it was a very primitive place, and even the places where they held court had to be very primitive. So the first meetings of the Supreme Court were held in a tavern.
When we think of a courtroom, we like to think of a formal space, usually with elegant chambers for the justices adjoining, somewhere nearby a well-fitted out law library, clerks silently pushing papers around. Let us say that the Supreme Court and its predecessor, the Superior Court, did not enjoy such luxury early on.
Well, it was a very rural setting. In fact, they really didn't have a home at the time.
As far as we know, the Superior Court of Arkansas Territory met the same place the legislature did, in a tavern in Arkansas Post. After the government moved to Little Rock in 1820, they met in a variety of places. For a while, the court met in a Baptist meeting house. They met in the homes of a couple of prominent politicians, Henry Conway and Chester Ashley.
Which is a pretty obvious violation of the principal judicial standard of independence, that the courts are supposed to be independent of the other two branches of government, and here they are meeting in the homes of the governor and other territorial figures and even members of the legislature.
In 1836, with the coming of statehood, we see the court finally moved into the East Annex, which is today the state wing of the state's first capital, today known as the Old State House. The one description we have of the space makes it clear that it was a fairly Spartan place.
There was just, I think, maybe a few wooden desks and no great law library.
Now, during the Civil War, of course, the Supreme Court, like the rest of government, takes a vacation. They adjourn briefly in 1862. The government is ordered to relocate by Governor Rector. The original plan is to go all the way down to Washington. They make it as far as Hot Springs. We don't know whether or not the Supreme Court actually went along with this relocation. We do know that in 1863, before the federal capture of Little Rock, the Supreme Court goes with the rest of government down to Washington, down in Hempstead County, where they hold some sessions probably in the old county courthouse. At the close of the war, the Capitol, the old State House, as we know it now, was a mess. Accounts suggest that the federal troops, as they departed, left no stick of furniture unbroken or unstolen. Probably a lot of souvenirs went back home. But the Supreme Court moved back in to the East Wing, along with county courts, along with a federal court. It was not until 1885, I believe, that they were finally able to get the county folks to go someplace else, making room for decent, redecorated chambers for the justices, probably a refurbished courtroom in which to hear cases as well.
I guess the most controversial era was, of course, Reconstruction. And when the Supreme Court, which ordinarily at least tried to give the appearance of being above the fray, above politics, but during the Reconstruction era and the famous Brooks-Baxter War, the Supreme Court and its Chief Justice, Poker John McClure — Poker John was not his actual name, but that gives you an idea of the personality and the character of the Chief Justice. And he got deeply enmeshed in all of the intrigues and warfare inside the state government, or who was going to control the state during that period of Reconstruction.
Like many who were influential in Arkansas politics post-war, he was a former Union Army officer who had relocated to Arkansas, seeing opportunities. It is hard to quite sort out his motives and intentions in the months and events that lead up to the Brooks-Baxter War. Of course, we have the questionable election, which leads to the selection of Elisha Baxter as governor, acceptable to one faction of the state's Republican Party, but not to the other faction, who were headed by a more earnest reformer named Joseph Brooks. We know that in the summer of 1873, Justice McClure attacks Governor-elect Elisha Baxter's legitimacy in the columns of his paper, the Little Rock Daily Republican, calling Baxter the dirty, cowardly, lying, dissembling wretch who now holds the office of governor. we have McClure plotting with Powell Clayton and other Republican insiders in 73 and early 74 to figure out how to work through a succession, how basically to ease Baxter out of the governor's office. And the election of 1872 having been contested by Joseph Brooks, you have a claimant there who keeps bringing court actions, trying to get a court to recognize that in fact he had been the legitimate winner of the 1872 election. The details are almost impossible to explain. The important thing to remember is that through the events of the Brooks-Baxter imbroglio, you have John McClure basically manipulating things. You have McClure, who'd been impeached from office once, returned to office, ultimately opting to support a lower court's action that, in effect, gives Joseph Brooks the governor's office.
So it was a bad period for the Supreme Court, and I guess probably the worst period for the Supreme Court in its history. Throughout that first century, or first 3/4 of a century of the court, when it was occupied the old State House, the court made a lot of important decisions that are still kind of the law today.
It covered just basic questions of, well, initially slavery, of course, being an issue about slavery, and then the property rights of people, property rights of slaves.
Of course, transportation in those days was largely railroads. And so it established the right of people to, under the Constitution, to get recovery from injuries by the railroads and so forth, which were very powerful institutions in Arkansas, politically powerful institutions.
Then, of course, setting out to the criminal code and what violations are criminal in nature and subject to punishment.
And it also established some law that is, I guess, kind of overturned in modern times on an issue that is a very high-profile issue now, which is the gun laws and the Second Amendment.
Until 1842, there was really no rules or regulations in the state of Arkansas concerning the carrying of weapons, but there was a case there. Incidentally, one of the parties was named Buzzard. That brought about the first case in Arkansas.
But the court said that the Second Amendment was written and designed simply to guarantee the continuation of state militias.
The pendulum has kind of swung back the other way. And not too long ago, in fact, I think it was 2008, that the United States Supreme Court, in an opinion by Justice Scalia, said really the Second Amendment doesn't really mean that much when we say to maintain a militia. The main part of the Second Amendment was right to bear arms. And this right to bear arms is an individual right. And Scalia's opinion, which is the federal law, said also the state has a right to impose regulations based on this case. So that's where we are as far as current litigation on weapons.
To summarize the nearly 11,000 cases that the Arkansas Supreme Court considered during its time meeting in the State House is almost impossible. If you look at the bulk of the Arkansas reports, you see the staggering amount of verbiage. You see the judges very careful abstracting of the matter before them, and then you have decisions issued in excruciatingly detail-conscious prose.
So when you go back and read some of the opinions of that era, you have to be somewhat impressed of the scholarship of these early justices. Not always did they reflect the kind of justice we would kind of expect, but their scholarship seemed to be pretty good. It was sometimes even impressive.